We are really delighted to have one of the, I think, heroic lawyers who brought this case, who was one of the lead attorneys on it. Her name is Jenin Younes. She's a civil liberties lawyer and a writer as well. She's currently the litigation counsel for the New Civil Liberties Alliance. She spent the early part of her career as an appellate public defender, providing representation to indigent clients that faced criminal prosecution. And she briefed numerous appeals courts and several cases in the highest state court, which is the New York State Court of Appeals. So she's a very experienced lawyer. She was one of the lead lawyers arguing this case, which is Missouri versus Biden, which is in the Fifth Circuit. And as we just summarized, that led to this preliminary injunction in the district court, and now largely an affirmation in the Fifth Circuit Court of Appeals. Thank you so much for taking the time to talk to us. We're thrilled to have you here, and congratulations on your important victory.
Oh, thank you so much for having me.
Absolutely. So let's just start at the beginning. Talk a little bit, if you could, about how this case came about. What led to this lawsuit emerging?
Well, as you've discussed, the lawsuit emerged from various actions taken by the Biden administration. So this was focused much more on the executive rather than Congress. In the spring of 2021, Jennifer Psaki, the White House press secretary, Biden himself, the Surgeon General, started making statements threatening tech companies, basically saying, if you don't censor more COVID misinformation, especially about the vaccines, anything that might deter people from taking the vaccines, we're going to look at our options. We're going to see what we can do, because this is killing people, basically. And of course, the platforms are very nervous about that. They don't want more regulation. They don't want negative repercussions from the government. They have motivations to keep the government on their good side. So they began censoring more social media users, especially about COVID. And that's actually the plaintiffs that I'm representing in this case were primarily censored on COVID-related topics. So epidemiologist Jay Bhattacharya, Martin Kulldorff, a psychiatrist named Aaron Kheriaty, and an activist named Jill Hines, who fights for health freedom. So
and just to interject there about those plaintiffs, these were actually people, American citizens, who were expressing dissent, a lot of them based on their specialty as scientists or medical professionals, expressing dissent to Dr. Fauci's pronouncements or the pronouncements of the CDC about the efficacy of vaccines or masks or COVID in general. And the government was directing big tech platforms specifically to remove their post or otherwise block them from being heard?
That's exactly right. And actually, per your earlier discussion, these are not people who come from the political right. I'm not exactly sure what each of their politics is, but I'm very certain they're not all conservatives. So this was just government dissenting from the government and government policies. I actually came to be involved in the case because I had brought an earlier one. I had become alerted to this issue when the Surgeon General and Jen Psaki started making these statements in around April or May of 2021. And I was like, well, this is a First Amendment violation. So I represented 3 Twitter users who had been suspended permanently from Twitter for similar types of tweets. And that case was unfortunately dismissed by a judge in a federal district court within the Sixth Circuit. But because they were aware of my work, the attorneys general asked me to join on behalf of these 4 plaintiffs.
Let me just ask you, though, about that dynamic that you referenced. I understand you're here in your capacity as a litigator and a legal expert and not a political pundit or an analyst. Nonetheless, I do want to just kind of delve in a little bit to how bizarre this idea is that the New York Times said that this is a victory for conservatives. I have to say, in the 20th century, when I was coming of age politically, the idea that we have to oppose state censorship of our political speech was very much associated in many ways with the left. There was certainly some sentiment on the right, but it was kind of the time of the moral majority and Jerry Falwell and Ronald Reagan and Pat Robertson, and this idea that the government was trying to censor music or censor the content of our expression was something that was largely associated with the religious right, and the left was very vocal against it. A lot of the landmark cases of the 20th century came from a lot of the left-wing or judges or Democrats appointed on the court, but there was a lot of Republican support for the idea of the First Amendment as well. It never really had this kind of partisan Democrat versus Republican, liberal versus conservative kind of feel to it because it was about the Constitution and free speech, a kind of value that I think transcended for a long time ideological conflicts. And yet now here we have this idea that if you question health authorities, people of the executive branch about a major issue involving pharmaceutical companies and their products, that you ought to be censored. And if anyone stands up and objects, that somehow reads or codes as a right-wing viewpoint. Have you noticed that, and what do you make of that?
Yeah, I've spent a lot of time thinking about that as someone who doesn't really identify as a political conservative myself, in case, as you might have surmised from my biography. I actually
you are just to be clear, you are a public defender representing indigent criminal defendant. So that's not typically work associated with the conservative cause.
Yeah, I mean, I haven't figured this out entirely. I think there are a few different issues at play. One is that the Democratic Party has just become more and more intertwined with corporate interests, and the tech companies themselves, and then pharma companies. So when people began posting stuff that threatened the success of the Pfizer vaccine, for instance, or frankly any of the COVID vaccines, I think the Democratic Party was very interested in trying to get rid of that in order to benefit their pharmaceutical company partners. Another phenomenon that's at play, I think, is what I call Trump derangement syndrome. I know other people use this term as well. Just that Trump is so reviled by Democrats that anything he says, it's got to be the opposite. So if Trump says that masks are silly, then obviously they're very good, and we've got to shut up anyone who says any otherwise. And I think that's really come into play with this this phenomenon.
So I certainly think this ruling is incredibly significant. The court has pretty much said they think it is. Both the district court judge and the appellate court said essentially that this was of a magnitude of censorship they've rarely seen, if ever. And yet I think because the media has mostly buried it or downplayed it on the one hand, but also on the other, I think a lot of people are kind of jaded and saying like, well, what is this really going to change? How are we going to know for sure that Biden officials are going to actually stop doing this when they were doing it in the first place, when it was so obviously unconstitutional? What would you say about the significance of this ruling, and what would you say to people who are kind of cynical about whether this will actually change anything?
Well, first of all, when the district court issued its preliminary injunction, the government did say that it had ceased its communications with social media companies, which is some positive indication that they might listen to the ruling. But more importantly, I think once the law is clear and you have a clearly defined ruling like this saying that this sort of conduct violates the First Amendment, people can sue for damages. It's harder for officials to get qualified immunity. So there are motivations for the actors themselves to not violate the court's ruling.
And just explaining that a little bit, meaning, and I want to ask you about this in a second, which is if a government official is kind of in doubt or like has a good faith basis for believing that maybe their actions are constitutional, you can't really sue them because you don't want government officials being easily sued. But once there's a court ruling explicitly stating that this behavior is barred, and then they go and do it anyway, you have a lot stronger case that they did it knowing it was illegal, and that's when they can be opened up to liability. Is that a fair summary?
That's exactly what it is. And I mean, look, frankly, here, it should have been pretty clear to these people that they were violating the First Amendment, especially some of them, like a guy named Rob Flaherty, who worked in the White House. He was calling the tech companies, berating them, threatening them, saying, if you don't censor more, if you don't take this down, we're going to look at our options. We're going to see what we can do. And the platforms were then writing back and saying, okay, we've changed our policies. We're censoring more. I mean, I'm summarizing. They didn't use exactly those words, but it's clear that that's what they were doing. And I actually worked for a bit on the subcommittee that is investigating this issue on the House Judiciary Committee. And they got access to a lot of internal emails from Meta that showed the company was actually, people within the company were talking and saying, why did we suppress the lab leak theory, for instance? And another executive writes back and says, well, it's because we were under pressure from the White House. We shouldn't have done it. That's pretty clear evidence that the government is the driver behind this censorship. So they had argued for quite some time, oh, we're just telling these companies what we want. They get to make their own decisions. We're just making our preferences clear. And that it's obvious that that's not what was happening.
Let's just, to make this a little bit concrete, let's just remind the audience of the kinds of things that were being censored. So I think the government, the New York Times in that account, want to make people believe that the only things that were being censored were obviously false and dangerous information, meaning people saying, oh, if you take the vaccine, you're going to likely drop dead of a heart attack within the first 8 hours. 50% of people who take the vaccine die, things of that nature. The reality, though, was, according to Mark Zuckerberg, he said that the government was pressuring Meta constantly to remove views that turned out to be true, not just debatable views, but views that actually turned out to be true. They were requiring or forcing Facebook to censor. So if you could just give a few examples from the plaintiffs that you represent and the kinds of things they were saying that ended up being censored.
Sure. So questioning whether lockdowns were a good idea. So these were policy debates. One, Dr. Kuhldorff had a tweet censored that said, masks give older people a false sense of security because they don't actually work that well. So maybe they're not taking other precautionary measures if they use them. He was also censored for a tweet saying that if you have natural immunity, you don't need to get the vaccine. It's excellent for older people. It's not necessary for younger people or people with natural immunity. I mean, this is an opinion. You can differ from it, but it's not, I don't think anybody could call that misinformation. Another thing that was quite shocking, and this wasn't the plaintiffs in this case, but actually another case that we have at NCLA is people who suffered themselves severe adverse reactions from the vaccine. One of them was actually diagnosed by the NIH, as vaccine injured. She was in the AstraZeneca trials. So this isn't an anti-vaxxer. She got the vaccine herself. And the White House was making specific requests that these people be taken down because their discussions about their injuries were dissuading people from getting vaccinated.
Even though they were true, right? Like not even Dr. Fauci denies that there are cases where people are injured because of the vaccine. Every vaccine can have side effects and does. So these are people who were just wanting to talk about their personal experience, doing so truthfully, but because the government was fearful of the effects that their truthful speech would have, they demanded these platforms censor those people.
Exactly. The tech companies and the White House even acknowledged that this was true content. They called it even true content that might cause vaccine hesitancy. So, I mean, this should be pretty shocking, I think.
Just to give the other side, like I showed in this, my monologue, this is something that has been driving me crazy for a long time. Like I didn't really even understand why this hadn't been challenged under Bantam Books. Reading that case seems so clear to me. Now, I realize there is this line that exists that might be somewhat blurry, where you can't bar the government from calling a media outlet, which is kind of what these social media companies are, and trying to persuade them not to publish things. This happens all the time. If you're a journalist, when we were doing this Snowden reporting, when I've done other stories, the government calls you or you call them and they make their case about why you shouldn't publish something, why it isn't accurate to say it, why it might be dangerous. But then the decision is yours entirely. And no one thinks that's a First Amendment violation because all they're doing is giving their input, which they have to have the right to do, but they're not threatening you, they're not coercing you, they're not forcing you to do it. And then on the other side of the line is where it's so clear that the government is threatening actual state punishment for failure to obey their censorship orders, which is the Bantam Book case and that line of cases. How did the government here try and claim that they were in either the right side, they were on the right side of the line only, or were in that kind of blurry area where it wasn't so clear?
So they said exactly that. We're exercising our own First Amendment rights to let the platforms know what our preferences were. I'll also say, I think, frankly, that they lied because we got a lot of evidence through discovery. The judge in the district court awarded preliminary injunction-related discovery, which is pretty rare, and that gave us access to a lot of the most shocking emails where you had the White House emailing the tech companies and berating them and threatening specific repercussions if they didn't, censor in accordance with the government's demands. So the government was saying, no, we're just not doing this stuff. You're wrong. And we've found out otherwise, and then the subcommittee also got evidence to the contrary. So I think the line is a little bit difficult to draw, and that's why some people are taking issue with the Fifth Circuit's limitations, where they said that entwinement, for instance, so the government being heavily involved but not coercing or driving the decisions is okay. And there are other people who think entwinement, the government being extremely involved, as it was with CISA sort of flagging posts saying this is the type of thing we think you should be taking down, but not making direct threats. I think there's an open question as to whether that's okay or not.
So obviously these companies are incredibly powerful companies. They're very wealthy. They're very rich. They have a lot of influence and power. So, but in general in our country, nothing is really more powerful than the government when they want to kind of corral their power and bring it to bear on the head of somebody. We're seeing that now with Elon Musk and threats of all kinds of investigations and the like. Talk about some of the threats or reprisals the state is capable of fulfilling or that they threatened in response to or as punishment for the failure to obey their censorship orders.
The biggest one, I think, is Section 230. So Section 230 protects the platforms from liability for things that people post on it. And this is sort of important in the era of social media, because if the platforms can be held liable for posts, it's going to be hard to just have a sort of free and open discussion. I think the platforms are going to start to have a huge motivation to moderate content very heavily. So they've, long feared repealing or amending Section 230 in a way that would not provide for those protections. And the government has specifically said, Biden and his communications director have specifically said they're looking at how 230 could be amended or repealed, and sort of making sure Congress knows what it wants in that respect.
Yeah, I also think it just can't be overstated how intertwined these big tech companies are with the federal government. Enormous amounts of contracts from the CIA, from the Pentagon, from the intelligence community that get awarded to various companies. And if the government wants to get vindictive or vengeful, they have all sorts of kind of insidious ways to punish them as well. So I know you can't predict for sure, but just for viewers who may not know, one of the potential options when a 3-judge panel in an appellate court rules is that you can appeal it to the full panel of 11 or 13 judges on the appellate court and ask for a full panel ruling, or you can try and appeal it to the Supreme Court. Do you have any indication yet from the Justice Department about their intentions, and do you have expectations about where the case is likely to go from here?
I think if I was going to place a bet, I'd say it's likely to end up in the Supreme Court. If I were the government, I would probably do that. They don't have that much to lose at this point, and the ruling is so, it makes them look bad, and they want to keep doing this. They want to keep censoring. So from their perspective, I guess I don't see why they wouldn't go to the Supreme Court. I'm not sure an en banc, so that's the full panel of the circuit. I don't know if they're going to do any better there, because the Fifth Circuit is sort of known to be conservative, quote unquote. And so if I were in their shoes, I would probably try to go to the Supreme Court.
Yeah, I mean, the Supreme Court, I guess, is known for being a little bit conservative these days, too, so it'll be really interesting to see. But I just want to emphasize, and this is part of my congratulations to you, I think people have to be aware, somebody who was a lawyer for a long time, I know this personally, it is very rare for a court to issue a ruling like this that is so scathing about the transgression of the federal government, especially when it comes to things that have long been considered to be within the prerogative of their executive power, to rule that they went so far over the line that an injunction is necessary against the government to enjoin them from doing it, especially this kind of broad-scale behavior of communicating coercive threats to big tech, is something that even though I thought the case is so clear-cut, I honestly wasn't expecting. And I don't know if you were, but I really want to congratulate you. I know these victories are very hard-earned and not all that common, so I hope you enjoy it. And honestly, as somebody who does believe in the First Amendment and the virtues of a free internet, somebody who's fought for it a long time, I'm really grateful that there are people like you out there fighting for it. I think this case is incredibly important, and I want to congratulate you for winning it.
Oh, thank you so much for having me.
Absolutely. It was great to see you. Good luck.
Yeah, thank you.
All right. So we will be back just after this very quick break, and then we have a second segment for you. So we'll be back right after this.